Several concepts from law and psychology influence rights in the employment relationship, including employment at will, wrongful or constructive discharge, just cause, due process, and organizational justice. Employers that run afoul of employment at will restrictions may be guilty of wrongful discharge, which involves the termination of an individual's employment for reasons that are illegal or improper. Employers can take several precautions to reduce wrongful discharge liabilities. Having a well-written employee handbook, training managers, and maintaining adequate documentation are key ways to prevent wrongful discharge. A landmark court case regarding wrongful discharge was Fortune versus National Cash Register Company in 1977. The case involved the firing of a salesperson, Mr. Fortune, who had been with National Cash Register or NCR for 25 years. Mr. Fortune was terminated shortly after he sold a large customer order that would have earned him a substantial commission. After reviewing the evidence, the court concluded that he was wrongfully discharged because NCR dismissed him to avoid paying the commission, thus violating the covenant of good faith and fair dealing. Closely related to wrongful discharge is constructive discharge, which is the process of deliberately making conditions intolerable to get an employee to quit. Under normal circumstances, an employee who resigns rather than being dismissed cannot later collect damages for violations of legal rights. An exception to this rule occurs when the courts find that the working conditions were made so intolerable as to force a reasonable employee to resign. Then, the resignation is no longer considered voluntary, but is effectively an involuntary termination. Dangerous duties, insulting comments, and failure to provide reasonable work are examples of actions that can lead to a claim of constructive discharge.